A mother dials 911, her voice steady but distant, and everything that follows will be argued in courtrooms for years. How do we make sense of the rare, devastating cases where a parent ends a child's life? When is the cause a crime? When is it an illness? And what happens when the system gets it wrong? And here's the hardest question: are there warning signs we can recognize and respond to before a tragedy unfolds? Stay with me. By the end of this episode, you'll understand the legal definitions that matter, the mental health conditions most associated with these cases, the role of safe haven laws, and what 5 landmark U.S. cases, some notorious, some overlooked, teach us about justice, bias, and prevention. How we'll open court records and peer-reviewed research, avoid speculation, and bring nuance to a subject too often sensationalized. We begin with a woman whose name became shorthand for postpartum psychosis, yet the legal outcome was anything but straightforward. We'll come back to why one expert's TV mistake changed everything. You're watching a faceless investigative channel dedicated to careful, evidence-based true crime. No reenactments, no graphic details, just the record, the context, and the questions that matter. Content warning: this episode discusses child death in non-graphic terms. We protect victim privacy and avoid unnecessary names or imagery. If you need to skip this topic, we understand. Our thesis today is simple. This is not about sensationalism. We're examining women in U.S. prisons connected to the deaths of their children, what the courts concluded, what mental health experts observed, and where the system succeeds or fails. We'll also spotlight prevention resources and how safe haven laws and maternal mental health supports can save lives. Let's set our terms. Filicide means the killing of one's child. Infanticide is often defined as the killing of a child under 1 year old. Neonaticide refers specifically to a death within the first 24 hours after birth. In the U.S., there is no universal infanticide statute, like in some other countries. These cases are prosecuted under general homicide laws, though a few states recognize postpartum conditions during sentencing or commitment. What do we know about prevalence? According to analyses of FBI supplementary homicide reports and CDC data, child homicides are rare overall, and most infants and young children who die by homicide are killed by a parent or caregiver. Infant homicide risk peaks on the day of birth and in the first year of life, with rates higher than at any other age in childhood. But remember, these cases are still statistically uncommon, and the majority of parents with postpartum mental health challenges never harm their children. Risk factors consistently identified in research include untreated mental illness, especially postpartum depression and postpartum psychosis, intimate partner violence, substance use disorders, social isolation, and severe unaddressed stress or trauma. Postpartum psychosis, a psychiatric emergency, can include delusions, hallucinations, confusion, and drastic shifts in mood and behavior. It's rare, affecting approximately 1 to 2 out of 1,000 births, but it carries a significant risk of harm if untreated. 2 life-saving resources up front: the National Maternal Mental Health Hotline at 1-8339-HELP-4MOMS, and Postpartum Support International's helpline at 1-800-944-4773. There's also the 988 Suicide and Crisis Lifeline, the National Parent Helpline at 1-855-427-2736, and the National Domestic Violence Hotline at 1-800-799-SAFE. You'll find these numbers again at the end. One more key framework: safe haven laws. Every U.S. state and D.C. allows a parent to legally and anonymously surrender a newborn at designated sites, often hospitals, fire stations, or police stations, within a set time frame without fear of prosecution, assuming there's no abuse. Yet many people don't know safe haven exists, or they fear being seen. We'll see in one Utah case how a lack of connection to care, or an inability to use it, had tragic consequences. We'll return to that. Chapter 1: The Andrea Yates Case, Postpartum Psychosis. On trial, Texas, 2001. Time and place: Houston, Texas, June 2001. Background: Andrea Pia Yates, a former nurse, married, 5 children under the age of 8. Medical history: documented severe postpartum depression and postpartum psychosis following earlier births. There were prior hospitalizations, medication adjustments, and warnings from clinicians about the risk of recurrence. In the months leading up to June 2001, Yates's mental health reportedly deteriorated. Family members and clinicians noted signs of psychosis. On the morning of June 20th, she called police and then her husband, acknowledging that she had taken the lives of her children. The details are well known, but we will not repeat them here. Yates spoke with police and mental health experts. Multiple psychiatrists concluded she was psychotic at the time of the offense, describing religious delusions and profound disorganization. At trial, expert testimony became pivotal. The prosecution relied in part on a forensic psychiatrist who cited a fictional TV plotline to challenge the defense's psychosis narrative. Here's the first twist. That TV episode didn't exist the way it was described. We'll come back to why that mattered, legally more than almost anything else. Yates was charged with capital murder. The defense argued legal insanity, meaning under Texas law at the time, she did not know her conduct was wrong due to severe mental disease. In her 2002 trial, the jury rejected insanity and found her guilty. She was sentenced to life in prison with the possibility of parole after 40 years. In 2005, a Texas appellate court reversed the conviction, citing the prosecution expert's false testimony about that TV episode. The court held the testimony likely influenced the jury and undermined the integrity of the verdict. On retrial in 2006, Yates was found not guilty by reason of insanity. She was committed to a state psychiatric facility where she remains. Coverage was intense and polarized. Some saw a monstrous act, others saw a textbook case of untreated postpartum psychosis. Mental health advocates cautioned against turning complex illness into entertainment. Ethicists noted the danger of overstating a motive when delusions drive behavior. The Yates case illustrates how legal outcomes can hinge on expert testimony and how a single error on the stand can decide between prison and psychiatric treatment. It also highlights a gap. The U.S. lacks a specific postpartum psychosis legal framework, leaving juries to apply general insanity standards to highly specific illnesses. When serious mental illness is proven but misunderstood, justice can swing wildly. But what happens when the opposite is true, when there was no crime at all? We look next at a teenager who became the only woman exonerated from death row in U.S. history. Chapter 2: The Sabrina Butler Exoneration. When CPR was mistaken for a crime, Mississippi, 1989 to 1995, Sabrina Butler was a 17-year-old first-time mother. One night, she found her infant unresponsive and attempted CPR before rushing to the hospital. The baby died the next day. Bruising from resuscitation efforts was misinterpreted as abuse. In an interrogation, Butler, young, grieving, and without a lawyer, signed statements that prosecutors used against her. In 1990, a jury convicted her of capital murder, and she was sent to death row. She has described the experience as an isolation few can imagine. In 1992, the Mississippi Supreme Court reversed her conviction, citing prosecutorial failures and improper jury instructions. At her 1995 retrial, experts testified that the injuries were consistent with desperate resuscitation attempts, not abuse, and that the infant may have died from a medical condition unrelated to any criminal act. The jury acquitted her. Butler walked free, later becoming an advocate for the wrongfully convicted. Butler's case did not draw the national attention of more sensational trials, but it's a crucial piece of the picture, because it shows how quickly grief can be misread as guilt, and how forensic interpretation can pivot from incriminating to exculpatory as better science and context emerge. Two themes recur in the research. First, that CPR and life-saving interventions can leave marks mistaken for abuse. Second, that youth, poverty, and lack of counsel increase vulnerability to wrongful convictions. Not every child death is a homicide, and not every homicide allegation holds up when science and due process catch up. But what about the cases no one could ignore, where investigators opened a storage space and made a discovery that stunned a neighborhood and a state? That's next. Chapter 3: Megan Huntsman. The Garage on Quiet Street, Utah, 1996 to 2006. Discovery in 2014. Megan Huntsman had been living apart from her estranged husband. He discovered a box in the garage during a cleanup and called authorities. Police ultimately found multiple deceased infants in separate containers. The timeline of birth stretched from the late 1990s into the 2000s. We will not describe the condition of the remains. Huntsman told investigators she had concealed pregnancies and delivered at home, then caused the deaths of the newborns. Prosecutors charged her with multiple counts of murder. She later pled guilty to 6 counts. One fetus was determined to be stillborn. In 2015, a Utah judge imposed consecutive terms of 15 years to life on each count, effectively 90 years to life. Huntsman is incarcerated in Utah. Her earliest parole eligibility is far in the future. Friends and neighbors described substance use and a life closing in, secrecy, isolation, and untreated addiction. Utah had a safe haven law since 2001, allowing anonymous surrender of a newborn at hospitals. But safe haven laws don't reach pregnancies that remain entirely hidden, and they don't treat substance use or mental illness on their own. If no one knows you need help, are you likely to seek it? That question hangs over this case. This case drew intense headlines because of the number of victims and the domestic setting. Yet the legal resolution was straightforward: a guilty plea, consecutive sentences, and a community asking how this went on for so long unseen. Neonaticide is strongly associated in research with concealed pregnancy, denial, lack of prenatal care, and fear of discovery, sometimes in the context of coercive relationships or addiction. Public health response, education on safe haven, confidential prenatal care, and targeted outreach to isolated or substance-using pregnant people remains crucial. Safe haven laws aren't a cure-all. Isolation can eclipse options that are legally and medically available. Open loop. But when motive becomes a media narrative, how do bias and myth shape the story we tell? To answer, we revisit a case that rocked America in the 1990s. Chapter 4, Susan Smith, a story that changed by the day, South Carolina, to 1994. Susan Smith reported that a carjacker abducted her 2 young sons. For 9 days, the nation searched. Smith appeared on television pleading for their return. Then she confessed. The car had rolled into a lake with the children inside. Authorities recovered the vehicle and the bodies. Smith admitted her role. The defense presented evidence of severe depression, a history of trauma, and suicidality. Prosecutors argued intentional homicide. In 1995, a jury convicted Smith of 2 counts of murder. The judge sentenced her to life with the possibility of parole after 30 years. As of this recording, Smith remains incarcerated. Parole reviews are governed by South Carolina procedures, and media reports indicate continuing scrutiny of any petition. This case became a cultural flashpoint, first for the false accusation against an unnamed black man, which fueled racial profiling and community harm, and second for the public's complex response to maternal mental illness claims. Many asked, if a father had confessed under similar circumstances, would the coverage have looked the same? Research suggests gender stereotypes, like the expectation that mothers are naturally self-sacrificing, shape both media narratives and juror expectations. Smith's case underscores how quickly a tragic event can become a national morality play, overshadowing careful inquiry into mental health, abuse history, and systemic failings. Say, when the public's first story is wrong, consequences ripple, from racialized suspicion to stigma around maternal mental illness. Our final case asks a courtroom to decide how bipolar disorder and sanity intersect when teenagers are the victims, and when meticulous planning collides with a claim of disease. Chapter 5, Julie Schenecker, Bipolar Disorder and a Florida Jury. Florida 2011 to 2014, Julie Schenecker, a former military linguist and mother of 2 teenagers, had a documented history of bipolar disorder and depression, including psychiatric treatment. Over a January weekend, both children were killed in the family home. Police responded to a welfare check and found Schenecker disoriented, odd with notes referencing her mental state. Again, we will not describe any physical details. Schenecker was charged with 2 counts of first-degree murder. Her defense argued legal insanity, pointing to a severe mood disorder, medication changes, and psychotic features. Prosecutors emphasized planning, purchase of a firearm, written notes, and argued she knew her actions were wrong under Florida law. In 2014, the jury rejected the insanity defense and found Schenecker guilty on both counts. She was sentenced to life in prison without parole. Appeals have not changed the outcome. She remains incarcerated in Florida. And coverage focused on the apparent conflict between mental illness evidence and indications of planning. Legal insanity is not a medical diagnosis, it's a narrow legal test. A person can live with serious mental illness and still fail to meet that legal standard. The case highlights how juries weigh intent indicators like preparation and concealment against psychiatric evidence. Psychiatry and law answer different questions. Mental illness does not automatically equal legal insanity. Juries often see meticulous steps as evidence of legal responsibility. So what determines whether a person ends up in prison, in a hospital, or fully exonerated? The answer lies at the intersection of law, medicine, and uneven systems. Before we unpack those systems, and before we answer whether safe haven laws, maternal mental health care, and expert testimony truly shift outcomes, consider this. In one landmark reversal, a single expert's misstatement reached across years to change a life. Does that mean expert testimony is too powerful, or that we're using it the wrong way? Here's the short answer. Expert testimony is essential, but it must be rigorous, transparent, and testable against the record. Now let's zoom out to the systems that shape every case you've heard today. Across states, sentencing for filicide varies widely because the same conduct can be charged under different statutes, first-degree murder, capital murder, or lesser-included offenses, depending on factors like premeditation, age of the child, and aggravators. Plea deals are more common when evidence of mental illness is strong but doesn't meet insanity standards, leading to reduced charges or concurrent sentences. In the neonaticide subset, some cases end in manslaughter or child endangerment rather than murder, particularly where concealed pregnancy, youth, or coercion are documented. All states have safe haven laws, but the eligible age window ranges from a few days to several months. Not every designated site is equally accessible. Public awareness is inconsistent. Studies show many new parents are unaware of safe haven timelines or locations. Importantly, unsafe haven timelines may not help with postpartum psychosis cases that occur months after birth, or with cases in which delusions focus on perceived moral or religious imperatives. Postpartum depression involves persistent sadness, sleep changes, loss of interest, and can include thoughts of self-harm. Postpartum psychosis is rarer and more acute, often involving delusions or hallucinations. Courts typically rely on the insanity standard. Did the defendant, due to severe mental disease or defect, not understand the nature of their act or not know it was wrong at the time? Expert testimony can clarify symptoms, timelines, and medication histories, but juries can and do reject insanity even when illness is proven, especially if there is evidence of planning or concealment that suggests awareness of wrongfulness. Some states allow verdicts like guilty but mentally ill, which leads to treatment in custody but still imposes criminal responsibility. Differentiating inflicted injury from injuries related to resuscitation remains challenging without context and careful methodology. Older pathology paradigms around shaken baby syndrome and suffocation have evolved. Courts increasingly demand rigorous, multidisciplinary evaluations. The lesson: certainty claimed too early can cause irreversible harm, especially in cases like Sabrina Butler's. Research suggests media portrayals differ by gender, race, class, and perceived fit with stereotypes about motherhood. Women of color and low-income defendants often receive less sympathetic coverage and fewer resources to mount mental health defenses. False accusations, as seen in the initial Susan Smith narrative, can stigmatize entire communities. Responsible reporting requires explicit caution about early claims, prevention and support. Screening for depression and psychosis during pregnancy and postpartum is essential. Early treatment saves lives. Integrating mental health care into routine obstetrics, pediatric visits, and home visiting programs can identify risk and provide support. Oh, community education on safe haven laws and confidential support without shame can offer immediate alternatives in neonaticide risk scenarios. Substance use treatment and domestic violence services must be accessible, trauma-informed, and coordinated with maternal care. And we as bystanders and family members need practical scripts. Are you sleeping? Are you hearing or seeing things that others don't? Are you feeling unsafe or afraid you might hurt yourself or the baby? Can I sit with you while we call your doctor or the 988 lifeline? Myth-busting. Myth: most filicide is committed by strangers or step-parents. Fact: parents and known caregivers are statistically the most common perpetrators of infant and young child homicide. So, myth: postpartum depression commonly leads to violence. Fact: the vast majority of people with postpartum depression do not commit violence. Postpartum psychosis is rare, and its risk can be reduced with prompt treatment. Myth: if you planned anything, you can't be insane. Fact: legal insanity focuses on knowledge of wrongfulness at the time, not on whether a person carried out steps while psychotic. Planning can coexist with delusional thinking. Juries have to weigh both. Let's connect these frameworks back to our 5 cases. Yates shows how expert error can flip a verdict and how a focused insanity framework matters. Day. Butler demonstrates how misread forensics can send a teenager to death row, and how reversal and acquittal can come only after years lost. Huntsman underscores isolation, addiction, and the limits of safe haven when pregnancies are concealed. Smith reveals how public narratives, including racialized assumptions, can distort truth and leave lasting damage. Schenecker clarifies how courts weigh mental illness against evidence of planning and how insanity in law and illness in medicine don't always align. Viewer prompt: based on what you've heard, how should courts weigh expert psychiatric testimony when planning is present but psychosis is documented? Tell us your thoughts with care and respect. So far, how we've seen that these cases are rare but catastrophic. Mental illness, especially postpartum psychosis, can be decisive but not determinative in court. Safe haven laws help in a narrow window. Broader maternal and family supports are needed. Media narratives can obscure facts, and bias can shape outcomes. Let's close the loops we opened. That TV error in the Yates case, it was enough for an appellate court to say, the jury heard something false. Justice requires a new trial. The teenager on death row? When science caught up, a jury acquitted her, and she used her experience to advocate for others. The storage garage in Utah? Oh, it proved that laws on the books can't help if people are too isolated or ill to use them. The case that gripped the nation. It showed how early false narratives can wound communities and shape attitudes for decades. And the Florida jury? It reminded us that legal sanity and mental illness are not synonyms, and that juries draw that line for better or worse. If you or someone you know needs support, here are non-graphic practical resources. National Maternal Mental Health Hotline 1-8339-HELP-4MOMS 1-8339435746 24/7 text or call. Postpartum Support International 1-800-944-4773 call or text help postpartum.net 988 Suicide and Crisis. Lifeline, call or text 988, chat via 988lifeline.org. National Parent Helpline 1-85-54-27-2736. SAMHSA National Helpline, Substance Use/Mental Health Treatment Referral 1-800-662-HELP 4357. National Domestic Violence Hotline 1-800-799-SAFE 7233 or thehotline.org. Safe Haven information, childwelfare.gov, search Infant Safe Haven, or your state's health department website for locations and age limits. We close with respect for the victims, children whose names we protect, families whose grief defies words. Our goal is awareness and understanding, not excuses, not sensationalism, but prevention where prevention is possible. If you found value in this careful approach, subscribe for more deep dive investigations. A. Share this video with someone who needs the facts, not the headlines. And tell us respectfully what should change, law, healthcare, media, to prevent the next tragedy.